Hello, everyone, and welcome to Uncivil Law. For today's case, we're dealing with a Second Amendment issue. The state of Maryland banned bump stocks and other similar devices, but when they did it, they didn't do it with a grandfather provision. They made it illegal regardless of people who owned them or not. They had to dispose them or otherwise. And so some people sued Maryland arguing that this was a taking because it was their property that they're being required to get rid of, and they had to be compensated. So the court is analyzing whether or not these people who own property which was lawful at the time they purchased it, and then made unlawful, whether or not they have to be compensated for that taking. Let's read on. On April the 24th, 2018, the Maryland governor signed a bill. The bill makes it unlawful for any person to manufacture, possess, sell, offer to sell, transfer, purchase, or receive a rapid fire trigger activator or transport such a device in the state. Violation of the law is a misdemeanor, subject to imprisonment for 3 years, a fine of $5,000, or both. The law defines a rapid fire trigger activator as any device, including a removable manual or power driven activating device, constructed that so, when installed or attached to the firearm, the rate at which the trigger is activated increase or the rate of fire increases. In addition, any other device which increases the rate of trigger activation or fire, the law specifies the following enumerated devices are activators. So, in addition to the general definition, we also have some specific examples. So, these are definitionally the things we're looking to ban in addition to anything else that would meet the category. These things include a bump stock, trigger crank, Hellfire trigger, binary trigger system, burst trigger system, or a copy of a similar device, regardless of the producer or manufacturer. The law exempts from the definition any semi-automatic replacement trigger that improves the function and functionality of the stock trigger. So if you want to do a trigger swap, that's okay, but otherwise, not so much. So the first issue that we have to decide in doing this is the issue of organizational standing, because the organization that's bringing this is a group called Maryland Shall Issue, which, as the name implies, would very much like to get shall issue permits in Maryland. It's not going super well for the organization, but they're doing their best, and they are suing over this as an organization on behalf of their members. So that raises an interesting question. When can an organization sue on behalf of either itself or on third parties? So this deals with a third party standing doctrine, and something that comes up a fair amount, and the court goes into a little bit of length as to third party standing. So before we get to the merits of the actual issue, we're going to go over the third party standing stuff because it's something that comes up a lot. When can an organization sue on behalf of its members? So let's read on. An organization can sue on its own behalf rather than as representative of its members when it independently satisfies these elements of standing. The plaintiff must have suffered an injury in fact, an invasion of a legally protected interest, which is concrete and particularized, and an actual or imminent, not conjectural or hypothetical injury is occurring. There must be a causal connection between the injury and the conduct, and it must be likely, as opposed to being merely speculative, that injury will be redressed by a favorable decision. A mere interest in a problem, no matter how long standing the interest and no matter how qualified the organization is not sufficient in and of itself to establish standing. So if you want to sue, you can't just say, we really care about it. You have to show a way that you are being harmed by the regulation as it exists. Here, the organization has alleged only that the law has undermined its purpose and message. It did not allege that it has expended significant new resources, nor did it explain how it has perceivably impaired its activities. Instead, the organization only alleged at most a setback to its social interests. And as this court has explained, to determine that an organization that decides to spend its money on educating members, responding to member inquiries, or undertaking litigation in response to legislation suffers a cognizable injury would be to imply organization for merely abstract concerns. MSI alleged injury is no more than a mere disagreement with a policy decision which is insufficient of itself. Accordingly, we agree with the district court that the organization lacks standing. So we couldn't get the standing here, but there are some individual members that also have some complaints. So MSI can't bring suit, but there are some members who have been impacted, so maybe they can bring suit. Let's talk about them. As to the individual members, the appellants also argue the district court wrongly determined that they failed to state a claim that this law violates the taking clause and the Maryland Constitution to the extent it's analogous to the federal Constitution. So the people here have argued that there's a taking. Property has been seized for a public purpose without just compensation. But this is a regulatory taking, and it's also not of land, it's of property. So there's some differences there. So is there compensation due for this kind of a taking? Let's read on. The Fifth Amendment to the Constitution, which has been incorporated, provides private property shall not be taken for public use without just compensation. A taking can be of personal or real property, and it can be effected through physical appropriation by the government or through regulation that goes too far in depriving the owner of property rights. So some regulatory taking might be okay, but if it goes too extensive, it might be a problem. Relevant here, the people that sued claim the law affects a per se taking of their property, specifically because the provision permitting registration with the ATF is ineffectual, because we can't actually do that. Appellants argue the regulatory prohibition on one's ability to transport into the state or manufacture, possess, sell, offer to sell, transfer, purchase, or receive a rapid fire trigger activator is tantamount to a direct appropriation of property. So, there is this exception, but at the moment, ATF won't register it either because the ATF has also had recent ban on bump stocks. So, yeah, if you could get it registered, that'd be one thing, but no, not so much. So, that's ineffectual, and we can't possess, transport, sell. So, our property has been taken away from us. We have no property rights left, or so goes the argument. Against the backdrop of cases we have held in our other cases that South Carolina's ban on possession or sale of certain gambling machines was not a taking. There, the appellant previously had lawfully acquired the video poker machines for which it distributed for profit. When South Carolina passed a law making possession of the machines unlawful and subjecting them to forfeiture, the appellant filed a suit claiming regulatory taking and requiring a just compensation. We concluded we believe that the Supreme Court case law makes clear that gambling regulations like Act 125 per se do not constitute a taking. We came to this conclusion relying on Dreas versus Allard, in which the Supreme Court held government regulation, by definition, involves the adjustment of rights for public good, and Lucas, where the court noted, in the case of personal property, by reason of the state's traditionally high degree of control over commercial dealings, the owner ought to be aware that new regulation might even render the property economically worthless. Because gambling is an area where the state has traditionally enjoyed a wide latitude to regulate activity minutely or even to outlaw it, we held that appellant was well aware the South Carolina legislature might not continue to look favorably. The fact that this possibility came to pass does not yield a constitutional claim. So basically, the argument there is that because this is a particularly well-regulated area, that even though you purchased it at a time when it was lawful, you should have been aware that it could have been made unlawful at any time. And so you bought that with the knowledge that it could be rendered valueless. And so you can see immediately where the court's going to go over here, right? Because again, firearms tend to be well-regulated. Therefore, anything could be made illegal at any time. And so, like the gambling case, you have no compensation, even though you purchased it when they were lawful, because I guess you should have known better than to purchase something that was lawful, is basically the way that reads. In Horn, the Supreme Court did hold the first type of a per se regulatory taking. Direct appropriation applies to personal property. So if the government had acquired the property, had seized the property directly, that would be one thing. So the government does have a categorical duty to pay just compensation when it takes your car, just as when it takes your home, because nothing suggests personal property was any less protected than physical appropriation than real property. So again, you can see where this is going, right? And if you can't, I'm going to help you out. So if the government wants to take it for themselves, if they want it to become their property, if they want to appropriate it, if they want to seize it for themselves, that's one thing, right? So if the government takes your land, or they take your property, they take your car, they take your whatever, and now it's like, yoink, now it's my car. Well, we have to give you compensation for that. But what if they don't appropriate it, right? That's different, right? Because government isn't saying, well, we want the land, yoink, it's ours. No. They're just simply saying, you can't own the land. No, we don't want it. We just don't want you to have it either. So that's totally different. So if the state of Maryland had said, all your bump stocks belong to us, that would be one thing. But that isn't what happened. They just simply said the bump stocks are illegal and you can't possess them either. So yeah, that's totally a different thing somehow. Appellants overlook this distinction and how it applies in this case. The law does not require owners to turn them over to the government or to a third party. Regardless of whether today we would decide the case law the same way, which required forfeiture of gambling machines the same way, the Horn Court expressly preserved the reasoning behind the conclusion as it applies. Though the law may make the property worthless, owners are aware of that possibility in a place where they're tightly regulated. We could think of few areas that are more heavily regulated than firearms, so that's totally cool. And as a result, these regulations are for the public good. We didn't seize your things, we just made them illegal, therefore no problem. Thus, that is the end of the case of Maryland shall issue versus the governor of Maryland. In this case, Maryland made some things illegal, but they didn't seize them. So they didn't take them. They just made them illegal. So you only get just compensation if they're taken for a public purpose. They weren't taken. They're just made illegal. So I don't know. Boil them, mash them, put them in a stew, but you can't continue to possess them. Give them away, throw them in the trash. I don't know. But you can't continue to have them. You get no compensation. You lose. Good day, sir. And that is the end of the coverage of this case.